Keith Davidson from Albertson & Davidson. This video is intended to give you an overview of what you must do if you want your lawsuit to survive the death of a plaintiff or defendant. And there's some very technical requirements under the California Probate Code that you have to follow if you want your lawsuit to continue on, or if you haven't filed a lawsuit and you need to file a lawsuit against a deceased party, then the probate code sections will also apply to you. This subject is going to fall into three broad categories. So first, we're going to talk about a general statute of limitations that's going to apply to all decedents. Next, we're going to talk about the difference between claims that are already in litigation versus claims that aren't in litigation. And then last, we'll talk about the procedures that apply to every claim in every lawsuit in order to ensure that your lawsuit can continue. So let's start with California's Code of Civil Procedure, and this is Code Section 366.2. And this is the starting point of any analysis when it comes to any claims against the decedent, because this code section tells you that no matter what the statute of limitations may have been on your claim before the party died, once somebody dies, all of the causes of action against them, for the most part, will expire within 1 year of their date of death if you do not take action in probate court. So you can see here in subsection A that any action may be commenced within 1 year after the date of the death, and the limitations period that would have applied does not apply. So that's the important part. So that this 366.2A is going to take over for any other statute of limitations period. And then you'll see under B that there's a few exceptions, and the biggest one is going to be number 2, and that's where you have filed a creditor's claim in the decedent's estates. And you'll see in a little bit that that's where we're heading. So anytime that you have a claim against the decedent, whether the claim's already pending in court or whether you have yet to file, you ultimately are going to have to file a creditor's claim in their probate estate. And so we'll talk about that. Before we get into the specifics of what you need to do in order to preserve your claim, let's talk a little bit about one area where you don't have to file a creditor's claim in probate court, and that has to do with claims where you're suing and seeking insurance coverage and you're not expecting to go beyond the policy limits. And under Probate Code Section 550 and the sections that follow that, it'll tell you that subject to the provisions of this chapter, an action to establish the decedent's liability for which the decedent was protected by insurance may be commenced or continued if you've already filed against the decedent's estate without the need to join the personal representative as a party or successor in interest. Of course, again, this assumes that you're not going to seek any damages or liability beyond the policy limits. So if you think that you're going to need something beyond the policy limits, then you're going to have to go forward with the creditor's claim procedure. Or if you don't know, if you're not sure if you're going to exceed policy limits or not, then you're going to want to file a creditor's claim. But if you already have a pending lawsuit and you know you're within policy limits and you're only suing the insurance company, then take a look at Probate Code Section 550. Now let's talk about what you need to do if you do need to file a creditor's claim. There's two different scenarios that we're going to encounter. There's claims where no action has been filed yet, and then there's claims where an action's already pending. And both of those situations ultimately are going to require a creditor's claim, but you go about it in a little different fashion. So we're here in Chapter 8 of the California Probate Code, and we're going to start with Article 1 on claims where no pending action or proceeding has been filed. And you'll notice that under 9351, an action may not be commenced against the decedent's personal representative unless a claim is first filed as provided in this part. So remember, once somebody dies, they can no longer be a party to a lawsuit. The only person who could then be a party to a lawsuit is the decedent's personal representative of their estate. The good news is once you file your creditor's claim in the decedent's probate estate, it's going to toll the statute of limitations until that claim is rejected by the executor. So you can file the claim and the personal representative, also known as the executor, can choose to accept it and pay your claim, give you the money that you say you're owed, They can reject it and say, we're not going to pay this claim, in which case you're going to have to proceed with your lawsuit. Or they can accept it in part and reject it in part, in which case you're going to have to file a lawsuit if you don't like what they've rejected. Now, a lot of times people get confused because they say, well, a defendant died and I don't know if they have a probate estate. Nobody has opened probate. What am I going to do? And the answer is, well, you as a potential creditor, as a claimant, have a right to file a petition for probate, to open probate for any decedent. So if a defendant dies, you can open their probate estate by filing a petition for probate as a creditor. Typically what's going to happen is you're going to file your petition for probate, and then the decedent's family will probably come in and file a competing petition for probate because they might have a will or they want to be the ones who are executor, whatever it is. It doesn't really matter. Once somebody else comes forward to also file a petition for probate for that decedent, you can just let yours go. All you want is for probate to be open so that you can file a creditor's claim. Once the probate has been filed, you can file your claim and preserve your rights. We have a separate series of videos on how to fill out a petition for probate. And so we'll link that to this video here. You can see a link in the description below. And we also have a separate video on how to fill out a creditor's claim. You can see that as well. So once your creditor's claim has been rejected by the personal representative, then you have to file your lawsuit. Or if the personal representative refuses to give you a rejection, after 30 days, you can deem it rejected and file your lawsuit. What you'll find on 9353 is some more deadlines. So if your claim is rejected, and if the claim is due at the time notice is given, meaning this is a ripe lawsuit that you're going to file, then you have to file that lawsuit 90 days after notice is given of the rejection. And if you don't do that, then you'll be forever barred from filing your lawsuit. Therefore, it's very important that you pay attention to when your claim is rejected, because there's very strict guidelines to when you have to file your lawsuit after that point in time. Or after 30 days, you can just deem it rejected, go ahead and file your lawsuit, and you can proceed as normal. Now, one thing of importance, when you do file your lawsuit, make sure you name the personal representative as the party you're suing in place of the decedent. So if it's Bob Jones is the executor for the estate of Linda Jones, then you're going to list the party as Bob Jones, comma, personal representative for the estate of Linda Jones. Don't make the mistake of just naming the estate of Linda Jones, without naming the personal representative. Estates only act through their fiduciaries, through their personal representatives. And so if you don't name the personal representative, then you won't have a claim that can ultimately be paid on and will be valid if it ever goes to judgment. So if you go to judgment and you win, you're not going to be able to collect if you didn't name the personal representative. So to recap, if you haven't filed your lawsuit yet and you need to file, and the defendant has died, the first thing you must do is either open a probate for that defendant or see if somebody else has opened a probate for that defendant. Once the probate petition has been filed, then you need to file your creditor's claim as quickly as you can so that you can be sure to preserve your claims. And then once your claim has been filed, you have 30 days you have to wait for it to be deemed rejected, or if the personal representative actually rejects it before 30 days, then you've got 90 days to actually file your lawsuit. Once you go through those steps, you can file your lawsuit as normal. You'll name the personal representative as a party to the lawsuit, and you'll proceed just as if the decedent were still alive. Now let's talk about situations where lawsuit's already pending, and the probate code has a separate section for that. And it starts with Probate Code Section 9370. So where an action or proceeding against a decedent is already pending at the time of the decedent's death, so this is somebody who's already a named defendant and now they've passed away, then this is what you need to do. First of all, you have to file a claim in that person's probate estate. That's what we already talked about. The claim then is either rejected in whole or in part, or you deem it rejected after 30 days. And then within 3 months after notice of the rejection is given, you as the plaintiff must apply to the court where your civil lawsuit is pending and you must ask to substitute in the personal representative in the action or proceeding in place of the decedent. Notice 9370B specifically says that no recovery shall be allowed in the action against property in the decedent's estate unless proof is made of compliance with this section. So that means you have to show that you did these things, that you filed your creditor's claim, that after it was rejected or deemed rejected, you substituted in the personal representative as a party. If you fail to do any of those things, you're never going to be able to collect against the decedent's estate. And by the way, quick sidebar here, let's say that the decedent has all of their property in a trust and not in their probate estate. Can you still get to those assets? And the answer is yes, because when you file a claim against the probate estate, if the probate estate does not have sufficient assets to pay for your judgment and your claim, then you can collect against any revocable trust that was created by the decedent during their lifetime. So that means even if they have $20 million in the trust but zero in the probate estate, once you establish your claim, you go to judgment and you've done the right procedure in probate court, that claim will then be collectible against the decedent's trust where the $20 million is held, even though their probate estate has nothing. Now that we've talked about the steps that you have to go through in order to preserve your claims against the decedent, we can switch over to Probate Code Section 9150, and these are the procedures for filing a claim. These procedures are quite easy, and we've done a video on how to prepare and file a creditor's claim form, and you can see in the link below a link to that video, and that will show you how to properly prepare a claim and ultimately file it with the court so you can preserve your rights to continue the lawsuit. So I hope that provides you with at least some basic information and an overview of how this process works to keep your lawsuit alive. The next resources that you want to look at is our video on how to file a petition for probate, and separately our video on how to fill out a creditor's claim. The creditor's claim is so important because until you file that, the clock is ticking. Once you file the creditor's claim, your statute of limitations is told until the claim is rejected, or you can deem it rejected after 30 days and go ahead and proceed with your lawsuit. File the suit if it hasn't already been filed, or substitute in the personal representative if your suit's already pending.